This judge isn't mincing words today. Before we even hear the facts, the tone is crystal clear. This case isn't about sympathy, it's about accountability. And when a judge starts like this, you already know probation is hanging by a thread.
So don't put that on me, that if I send you to prison, that I'm somehow going to be hurting your kids or hurting your mom. You've done that. Victavia Sanders. And Ms. Sanders was previously here in cause number 22-39884. Entered pleas of true to counts 2 and 3 and a motion to revoke community supervision. I received an updated pre-sentence report. We're here for a sentencing hearing. Has everyone had an opportunity to review that report?
Yes, Judge.
Are there any additions or corrections to the report?
Your Honor, my concern, I guess I can address this after Mr. Smith had the opportunity to present evidence on the new offense, was that the recommendation appeared to be predicated on an assumption that the new offense had been proved up, and that was going to be my issue with the pre-sentence report. Of course, if Mr. Smith is prepared to prove it up, then
okay, let's go through that.
The necessity for me to go into that.
All right, we'll go through that first. And it's my understanding, and we spoke earlier kind of off the record, that the officer involved is unavailable, but that Mr. Smith has his body cam video footage from that date, and there's no objection to him putting that on as evidence in this hearing. Is that correct?
Here's a key legal moment most people miss. The officer can't testify, but the body cam still comes in. Why? Because video evidence can stand on its own if both sides agree. No witness, no problem. And that decision is about to matter a lot.
Mr. Kimler?
Yes, Your Honor, that's correct. My understanding is due to the exigencies of the officer being involved in the shooting, he's on administrative leave and is unavailable to testify. I therefore don't have any objection to the body cam being played in his absence.
Thank you, Mr. Kimler. And just let me know when you're ready, Mr. Smith. And Ms. Lopez is here. Thank you, Ms. Lopez. And at the appropriate time, if you have anything to add as well, I'll give you an opportunity to do that. And so the allegation in count 1 that was not pled true to or not is the allegation of a new theft of property from July 31st of 2025 here in Jefferson County.
He's got to play the video.
Patrol 115 into 6 cars.
Now watch closely. This isn't just store footage, it's the backbone of the state's case. Every movement, every reaction, every word, this is what the judge will rely on when deciding whether probation survives or collapses.
Hey, stop. You're being detained. Man in the back, please come up here. Hey, you're being detained, okay? Okay, we'll worry about that in a second. Just come over here so we can talk. Thanks. so you're not under arrest, you're just detained. And so, man, put your hands behind your back. I thought she was detained right now. She just took everything out and dumped it on the floor back there. Where everything at? Put your hands behind your back. Wait for everything.
Once already.
And just stay here.
I was
Do you have any other merchandise on your person? Anything illegal underneath you?
Like the case right here at the top.
They can take this. I gotta walk out the store.
Yeah, we did. I watched you on the camera.
What?
I watched you on the entire time.
Okay. What we're doing, look, if you have anything illegal, look at me. Hey, just look at me. If you have anything that you didn't buy, just stand it on the counter.
Can you take this out from me?
Not at the moment, no, because
I'm talking about.
way you're acting, you're acting like a fool.
Oh no, I'm not gonna do that.
You
This
act
stuff.
like a
I
fool.
promise I'm not.
Just like so, just put it all right here. Nothing else in your
No,
pants or
I'm not.
anything?
No.
Alright, let me.
All right, any other evidence? Count one.
There is also the footage from the inside of the car where both are detained, where she actually speaks to the other defendant without the cops being there, and she talks about how she was here and you told her not to do this. But I think that first video kind of sums everything up.
All right, any evidence with regard to count one before I make my finding?
Evidence, Your Honor, as in testimony.
And anything that could,
I'm looking at this trying to figure out if that's a legal search. I mean, she appears to be detained, so it's not a Terry search. It's a warrantless search, obviously. She's not under arrest and being searched at the jail.
they didn't search her. They said, if you have something, take it out. She took it out and she placed it on. They didn't even have to get to the search.
I guess she could have refused and remained silent.
But she didn't, and
She
so,
followed the direction. And there's
Yeah.
no Miranda issue since she wasn't
right.
arguably in custody. I don't have any argument. I will go ahead and object that that's an illegal search.
This is where defense attorneys lean forward in their seats. Was this a legal search? The judge explains it perfectly: no forced search, no custody, no Miranda issue. She voluntarily handed items over. That single detail just shut down the entire suppression argument.
That objection's overruled. I am going to find count one true. And so, let me see, I need to. Counts 2 and 3, she pled true to, so there's a finding of true. Count 2, again, everyone's had an opportunity to review that pre-sentence report. Mr. Kimler, you may make argument with regard to
Yes, Your
punishment.
Honor. At this stage, now that the state has offered evidence as to count, as to the new offense, and the court's found that to be true based on the evidence, I think that the recommendation comports with the state of the record. I would again defer to the probation department, but I think that they're seeming to indicate that the court is to keep her on probation, that she enter into the ISF program, cognitive track, and I would defer to that recommendation in lieu of revocation.
Mr.
Or proposal, I suppose. I don't know. It's the next word.
With the pending charge of this theft, she's not eligible to go to ISF.
If I may, she's set on that today. I can resolve that today in this.
No, it's pending in felony.
It's here,
Oh,
it's
is it here?
mine.
Okay.
Because of the prior thefts.
All right.
She's done with misdemeanor
Right.
thefts.
We could resolve that perhaps today, Your Honor. if the board-
I mean, go ahead.
The
What-
state, I feel like we have given her every possible chance to rehabilitate, and she has not taken that. We would ask that she be revoked and given, based on the number of thefts committed, that she be revoked and sent to the state jail for 2 years.
Ms. Lopez, do you have anything else to add to your updated report?
Everything in my recommendation.
All right.
This is the moment defendants hope will change everything. Kids. Family. A sick parent. But here's the hard truth: judges hear this every single day. And emotional appeals only work if they're backed by changed behavior.
So, do you want to address the judge?
Yes. I feel like I did, how can I say this? I feel like I can finish my probation off because of the simple fact, like, this is the longest I've ever been away from my kids, besides when I did 8 months, but they was younger than me, and like, I was younger, and like, they understand what's going on, and I understand, and like, me being away from my kids right now is really hard, because they be with my mama, and my mama had dementia, and she...
Stop. Stop with everybody else, because I'm not gonna make my decision today based on the fact that you have kids or based on the fact that your mom needs you, because you weren't thinking about that day. So don't put that on me,
No, I'm
that
not.
if I send you to prison, that I'm somehow gonna be hurting your kids or hurting your mom. You've done that. You were on felony probation, and it sounds like if the other video was played, you knew exactly what was gonna happen. If what Mr. Smith is saying is true, that y'all were in that car and you said, Judge West said, I better not do this again, and you did it again, it just makes me look like an idiot for giving you the opportunity.
That line right there, you are the wrong person, that's judicial reality. Courts don't care who influenced you. If you're there, you're responsible. And when a judge feels their trust was wasted, that's usually the end of probation.
In the first place. At some point, you have to stop. Some point, you have to stop. Anything else?
Judge, even based on what she told probation is, she wants to be reinstated on probation. She was just with the wrong person. The girl she was with already took probation. I
Right.
wasn't the one stealing.
Yeah,
So she
I made a
doesn't
note of that.
accept responsibility.
This is my responsibility.
You accept your responsibility now that we saw it on a video. You didn't accept your responsibility. You said you were with the wrong person. I'm gonna tell you like I tell everybody else. You are the wrong person. She was with the wrong person. Y'all were with the wrong, you're all, if you're in there doing it, you are the wrong person, right?
Yes, ma'am.
So you didn't take responsibility. You haven't taken responsibility. You were given this opportunity after having felonies and going to state jail for the same offense, and I gave you a probation, and I said, don't do it again. So at this time, I'm going to find again, count one, that there was sufficient evidence to find count one true, find it true, find that you pled true to counts 2 and 3, find sufficient evidence to revoke your probation, and at this time, revoke your probation, sentence you to a term of
15 months. Probation revoked. And this case ends the way many do, not because of one mistake, but because of repeated chances ignored. Drop your thoughts in the comments. Should the judge have given one last chance, or was this inevitable?
months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to,
I'll get the other one worked out today.
okay, I'll hold it while y'all do that, and then while I'm doing that, I need a, I'll hand you the trial court certification in just a minute after y'all do that on this case that shows this was not an agreement. You have some limited rights to appeal. If y'all want to go visit about the other one, I'll hold it. All right, go ahead, go back that way.